Hello folks, and welcome to my channel. If you like the content that I'm providing, please hit that like button and subscribe. Before I get started on this introductory video, I would just like to make a disclaimer for the record that this video and the two videos I present to you in this two-part video series is for entertainment purposes only and should never be taken as legal advice on the topics discussed below. I am not a law student, a paralegal, or an attorney. If you need help getting your constitutional rights restored or getting your gun rights restored, you should always seek the advice of a licensed attorney. Something else I want to make clear before we get into the discussions of this two-part video series is that these videos are not about how federal felons can get their gun rights restored through the ATF, because as we all know by now, Congress defunded that program. And last but not least, these video series are not about how federal felons can get their gun rights restored by a presidential pardon, because most of us know that we don't have a snowball's chance in hell of that happening in this lifetime. Part 1 is titled The Supreme Court Concerns and Their Case Law Developments Over the Years. Part 2 is titled The Argument the Supreme Court, Part 2 is titled The Argument the Appellate Courts and the Supreme Court is Afraid to Hear. What I hope to achieve through these video series is to bring clarity to the issues of gun restoration rights for those of us who have been convicted of federal crimes. With that being said, let me give you a brief synopsis of the topics the video series will cover. Part 1 is Supreme Court Concerns and their case law development over the year. In Beecham versus United States, the Supreme Court reviewed rulings from two appellate courts, the Ninth Circuit Court of Appeals, one that ruled in favor of arguments like the one Beecham brought forth, and the Fourth Circuit Court of Appeals that ruled against arguments like his. Beecham simply argued that the government of the state in which he committed his federal crimes took away his right to vote, hold public office, and sit on a jury after he was convicted of his federal crimes, and they restored them to him after he was done serving his sentence. And during the restoration procedures, they specifically gave him rights to own and possess firearms without any restrictions on how, when, and where he could possess them. Beecham argued that the state's restoration procedures made him sit squarely within the federal law exception clause of Title 18 United States Code, Section 921A20B, that excludes felons from being barred from owning and possessing firearms under Title 18 United States Code, Section 922G. The Supreme Court majority went on and said that the state restoration procedures were not enough to effectively restore his civil rights because his crimes were federal. The restoration of his civil rights had to be brought through federal law. In a footnote in Beecham's case, the justices expressly said that, and I quote, "We express no opinion on whether federal felons can have his civil rights restored under federal law. This is a complicated question, one which involves the interpretation of federal law relating to federal civil rights. See United States Constitution, Article 1, Section 2, Clause 1, the right to vote for representatives. United States Constitution, Amendment 17, the right to vote for senators. And Title 28, United States Code, Section 1865, the right to serve on a jury. Considerations of the possible relevance of Title 18 United States Code, Section 925C, which allows Secretary of State to grant relief from the disabilities imposed by Section 922G, and the determination whether civil rights must be restored by affirmative acts of government officials." He said, see United States versus Ramos, or whether they may be restored automatically by operation of law. See United States versus Hall. We do not address these matters today. So, what was it, 4 years later in Karen, they addressed those last few issues right there. They addressed those issues in that case, just to make note. And they said that restorations of your rights can be restored by operation of law. And they don't need no affirmative acts from the government giving you a token of forgiveness or whatever that is to prove that your rights was restored. So, in Karen versus United States, the Supreme Court denied him the protection of the Second Amendment of the Constitution when they said that his constitutional rights to own a gun was restricted by the state who restored his gun rights, and that for him to be able to take advantage of the exception clause in Title 18, United States Code, Section 921A20, he had to have had no restriction on how, where, and when he could possess a firearm, like all other citizens. The next development in the progeny of cases dealing with our Second Amendment right was in Logan versus United States. The Supreme Court denied him protection of the Second Amendment of the Constitution because it said that when he was convicted of his state crimes, he did not lose any of his core 3 constitutional rights. That is, the right to vote, the right to sit on a jury, and the right to hold public office, and then have them fully restored to him. And therefore, to be able to take advantage of the exception clause in Title 18, 921A20. So, the first video is going to go over, it's going to go over Beecham versus United States, and it's going to cover those topics right there. So I highly recommend that you watch that video and learn what's holding you back from getting your gun rights restored. So, part 2 is the video that comes up with the remedy that actually the guy Billy York Walker, he takes the mantle and grabbed the bull by the horn. He looks at that footnote in Beecham and says, okay, I did everything Beecham did. I went and got my rights restored through the state and everything that I could do. But I'm for to present my argument, just like the Supreme Court said somebody could, that they didn't take no issues with that. They didn't look at it that way. So in United States versus Billy Walker, he argued that he had his civil rights restored by federal law in accordance with the footnote in the Supreme Court case in Beecham versus United States. In this case, the Sixth Circuit Court of Appeal panel examined whether or not Walker had his civil rights restored in such a way that he qualified to sit on a federal jury according to federal law under Title 28, United States Code, Section 1865, the right to serve on a federal jury. And they determined that he had, in fact, satisfied the qualifying factors set out in Title 28, United States Code, Section 1865, which required him to have had his civil rights restored to vote, sit on a jury, and hold public office after being convicted in the state or federal court of a crime that carried a term of imprisonment of more than 1 year. You see, right there should have ended the Sixth Circuit panel's inquiry on whether or not Mr. Walker had his civil rights restored under federal law. But no, the panel said in so many words, we want to chase our tails and see if there is a federal statute that takes away and restores Mr. Walker's right to vote and hold federal office, knowing that they were not going to find any. But Mr. Walker goes on to say to them, I have something better than a statute. I have the United States Constitution, which is the supreme federal law of the land, and it delegates to the states the right to take away and restore my rights to vote, sit on a jury, and hold public office. So all the panel could do is go on and gripe, saying, well, the restoration rights process through the Constitution does not consider Walker's conviction, and there's no token of forgiveness offered by and through a federal government agency within this process, and therefore he has not had his civil rights restored in a way that comports with Title 18 United States Code, Section 921A20. It's weird how the panel can say in one instance, oh yeah, you've had your constitutional rights restored under federal law, and because of this, you now qualify to sit on a federal jury, and then turn around in another instance and say that Mr. Walker has to do the same analysis again for the other two constitutional rights. So say, for example, if they had statutes in place for the other two constitutional rights, wouldn't it be a little crazy and redundant to do that same analysis over and over, expecting a different result? Simply put, the Sixth Circuit panel did not want to accept the fact that the United States Constitution has delegated to the states the right to take away our civil rights and restore them, and by virtue of that authority, they can undo federal bans on ex-felons owning and possessing firearms. Another thing the Sixth Circuit panel failed to recognize is the fact that the state took away Mr. Walker's right and restored him because he was convicted of a federal offense. So that argument about the constitutional process he used to get his civil rights restored didn't take into account the crimes that he committed as false. So that's why I call Billy York Walker's case the case the argument the Appellate Court and the Supreme Court don't want to hear. This is just one argument on the front lines of the battle to restore nonviolent felons' Second Amendment rights to bear arms. As I speak, there are two very important cases in the Supreme Court. I'm not pronouncing it right. Falatar versus Barr and Holloway versus Wilkerson. Defendant in those cases challenged Title 18 United States Code 922G1 on its face as unconstitutional. The issues are whether a lifetime firearm prohibition based on nonviolent misdemeanor convictions violate the Second Amendment. And I hope those cases do go through, because it may have bearing on those of us who have federal felony convictions that are nonviolent, because the topic is about nonviolent offenses. And as the law stands right now, they don't even consider whether you have a felony or a misdemeanor. The whole thing, they bar you if you got convicted of anything and the sentence was for over 1 year. So this case is a very, very, very important case for us that might have bearing on whether we can get our gun rights back just on GP without going through all this stuff that I described to you, or just going through the process of getting everything restored. So some key points stated in the case law above. I said C. Logan. It said, while 921-820 does not define the term civil rights, courts have held a petitioner agreed that civil rights relevant under the above quoted provisions are the right to vote, hold public office, and serve on the jury. See brief for petitioner. Cross-reference Karen versus United States. Congress responded to our ruling in Dickinson by providing that the law of the state of conviction, not federal law, determines the restoration of rights as a rule, while state law is the source of law for restoration of other civil rights. However, it does not follow that state law also controls the unless clause. This is something that I didn't go over, but the unless clause is just a part of Title 18 United States Code Section 921A, where it says when you get your rights restored, as long as they didn't say you could not own and possess a firearm, or they didn't put any restrictions on how, when, and where you can possess a firearm, then you good. So under the government's approach, which we agree, the federal policy still governs the interpretation of the unless clause. We see nothing contradictory in this analysis. Restoration of the right to vote, hold public office, and the right to sit on a jury turn on so many complexities and nuances that state law is the most convenient source for the definition. Bet you they don't like that. They're gonna squirmish when we throw that back in their face. As to the possession of weapons, however, federal government has an interest in a single national protective policy broader than required by state law. Petitioner's approach would undermine this protective purpose. See, Karen. See, that's crazy because you know what they're trying to do. They're not trying to create any solutions to the problem. They keep on trying to put up roadblocks. See, like I said, with the federal government, when they review these cases, they bring up all these issues and problems, and then when somebody comes with a solution, they try to move the goalposts, and that's not right. They need to just leave it in the state's hands and let them deal with it. You know, people, it's up to people. If they get their rights restored in one state, and you plan on traveling to another state, make sure that that state is you good in that state. Just don't just, you know what I'm saying, go out. And I see that's kind of like what they were trying to speak to, but the federal government is not really built to do that. You know, I mean, they could, but when you have a government that's out to take away your rights, it'll never happen. You know, like I said, Billy York Walker, he had his rights restored. They said all three of his rights was restored, and that was under federal law. So the inquiry should have ended there, you know. But this court want to keep going round and round and chasing his tail and stuff, and that's not right. So back on the important footnotes, you say it says, see, Karen. We note these plenary points. First, Massachusetts restored petitioner civil rights by operation of law rather than by a pardon or the like. This fact makes no difference. Nothing in the text of 921-820 requires case-by-case decision to restore civil rights to this particular offender. While the term pardon connotes a case-by-case determination, restoration of civil rights does not. So that's big, you know. And when you go and look at the two videos that I put forward for you to see, especially in Billy York Walker's oral argument, you're gonna see he's gonna drive home all these points and stuff, you know, and he comes back on appeal and they still deny it. So this is gonna take, you know, one thing I noticed on each one of these panels, in Billy York Walker's case, or in the first case that I presented to you, it was always a judge that sentence saying, no, this is not right. Because, like I said, it's not all of them that's trying to deny our rights. It's most of them. But it's always some good ones on the courts or in Congress that want to do the right thing, man, and obey that Constitution, you know, not trying to put statutes above the Constitution and stuff like that, you know, because they jealously guard that power that they have, you know. That's not right. Hey, the law is the law. You know, if there's something wrong with it, let Congress fix it. So yeah, I just wanted to get that out there for the folks that were running into a lot of these other videos that talk about gun registration rights, and a lot of them they're talking about the gun restoration rights for those people who are convicted of state crimes and stuff. And I want to make clear, for the people that's convicted of federal crimes, you still have to go through the same process the people who committed state crimes. It's just that you got to make sure that you're good on that federal end. They do too, but they don't. The process that Billy York Walker went through, Beecham went through. If they had committed state crimes, the federal government wouldn't be on. They'd be good throughout the whole country, but they trying to distinguish us and not treat us correct under the Equal Protection Clause of the Constitution, and that's not right. And hey, make sure you're right before you go out there and try to own and possess a firearm. And another thing I need to bring up to you guys is that a lot of these people that's bringing these new challenges, they just went to the court and petitioned them. I don't have to cover how they did it, but right now I want to let y'all know, if you go and try to purchase a gun after you get your rights restored, whether you, especially if you're a federal, you have a federal conviction. If you try to go and purchase a gun, they could try to bring charges up on you. That's how bad they trying to stop us from owning our firearms and getting our rights restored. They don't even want us to go through that check. So whenever you do feel like you've got your rights restored, just petition the court. Don't go and try to purchase a firearm, and when they deny you, be like, oh, I have the right to go to court now. No, you go to court then and try to get some injunctive relief or whatever that these other cats in the Supreme Court did. Okay, so I'm out, y'all. Like I said, if y'all like this content that I'm providing, hey, hit the like button and subscribe. Peace.